Okay, good morning. My name is Vicki Sunnysack. I'm the Code Enforcement Officer for the Village of Westmont. Thank you for attending the first of 3 informational meetings that we are going to hold. These meetings are to help you in filling out the application, what to expect on inspections, tell you a little about the crime-free housing addendum, and some other elements of the ordinance that will be helpful in getting you to transfer and know how this ordinance is going to work. The way we're going to do this is we are going to go through a presentation, and if you could jot down any questions that you have, and after we go through our presentation, then we're going to have a question and answer period afterwards. I do want to let you know that this is being videotaped so that it can be viewed by the public on our local station for television purposes, for people who cannot make these meetings. If you do choose to, if you didn't get questions answered or you want to come to one of these meetings again, you may come back to another one of the other 2 meetings. That's perfectly fine, okay?
Yes.
They're all the same, yes. Our village attorney, our prosecuting attorney for code enforcement, is in court today, so she cannot be here. She will be at the next 2 meetings, and she was going to cover the crime-free lease addendum and eviction process, which I think is a very important portion of the presentation and that you, as landowners, are probably very interested in. Our detective Gabrielski is going to go over that today, but if you don't quite understand that process, please feel free to come to those other 2 meetings for those 2 portions of the meeting. Okay. So with that, let's jump right into it. First, let's go over the ordinance. Okay, as you know, the village board held several public comment forums on a draft ordinance. After those public forums, we took all of the comments and we got a task force put together with representatives of the village staff, landlords, tenants, and we drafted an ordinance that we felt was reasonable and addressed areas of concerns by all the parties involved. The village board then adopted the ordinance in August of this year, which is now going to become effective in January of 2010. Big question is, how does this apply to me, and does it apply to me? And we have had several calls on this already. A multifamily dwelling building. There's one owner. Do you own a building? Okay. Does it have 3 or more dwelling units inside that building? And are 70% of those or more being rented? So, the one question that came up and is a good example is, I have one building, it has 4 dwelling units in it, but I have 4 owners. In other words, it's a condo. Now, 3 of those owners have decided to rent out their condos. So now we have 75% of those units being rented out. That falls under this ordinance. Does that make sense? All right, let's go over the application real quick. This is probably the most important document that you're going to be filling out. Does everybody have a copy of the application? Okay, there's some in the back. If you want, share with your neighbor for right now. If we could turn on the overhead. Okay, we'll get some. We'll get some for you. I've got it here on the overhead, and if you can share with your neighbor.
Turn your phone down, man.
Okay. There is one application for each building. Some of you may own multiple buildings. You must fill out an application for each building that you own. So if you own a building in Willow West, if you own a building in the Ponds, if you own a building on Cass Avenue, you must submit 3 separate applications, okay? In section number 1 is the owner information. This is very important. Some of you may own it by yourself, private owners, that's fine. We do not accept P.O. boxes. We want real live addresses, okay? No P.O. boxes. Some of you own trusts, corporations, LLCs. That's fine. But we want the names and addresses of everyone who has an equitable interest in that property. And they must also sign the application, all right? Along with that, the biggest and the most important thing is emergency phone numbers. There's always times that we have emergencies during the midnight hours, early mornings, and even sometimes during the day where we cannot get a hold of someone if we have an emergency at your building. So we need an emergency phone number that we can get a hold of 24/7. And if you're not available, we'll get further into the application where we will show you how there are other remedies if you're not available or out of town. The next section discusses a managing agent. You do not have to have a managing agent, okay? If you do not have an office in your building, or you do not live in the building, or you do not live in Westmont, or DuPage County, or a county that is adjacent to DuPage County, then you must have a managing agent that manages that. Otherwise, you do not have to have a managing agent, okay? If you do have a managing agent, then you must fill out this section. Again, the same applies. No P.O. boxes, we want real live addresses, emergency phone numbers.
Vic,
Yes.
you said that if they're out of town, out of Westmont, other areas, they need a managing agent.
If they do not live in DuPage County or a county adjoining DuPage County.
And I think what we're getting at there, folks, is that we've got many landlords that may not even live in the state of Illinois. They live in other states or other countries. It's very difficult to get a hold of those landlords if there's a problem with that building. We really need some contact information for that reason.
Yeah, we'll take your questions when we're done, okay? Because we're going to have a microphone. Since it's being videotaped, you'll have to come up to the microphone so everybody can hear it, okay? All right. Here we go. The next section is if you have a janitor that possibly lives in the building or lives in Westmont, that you have that does the normal repairs or emergency repairs on your building. This section on page 2 is where you would fill that information out, okay? What I failed to mention is on the manager's information and on the janitor and engineer's information, we want a copy of the written agreement that you have between the two of you. In other words, we want to know what their powers are, what you are allowing them to do, what repairs do you allow them to do, okay? What access to the buildings do they have, okay? So we know that you are giving them permission to do certain things at your building, okay? In the section below janitors and managers, and again, you do not have to have any of those, that's only if you have those, are people that can accept notices and processes. What notices and processes are letters of violation, notices of any information, say ordinance changes, any kind of correspondence from the village, notices of violations, I covered that, citations, court notices, hearing notices, anyone that you can allow to accept service, okay? That information goes in that particular portion of the application. Again, no P.O. boxes, we must have real live addresses. The next section is talking about fire alarm systems. We want to know who's responsible for taking care of your fire alarm system. Okay? The name of the company, their address, no P.O. boxes. We want phone numbers, we want emergency phone numbers. All accurate information. All right? If you have an elevator in your building, most of you do not, but if you do, we want to know who's responsible for making the repairs, or any, if there's a problem with the elevator, who's going to take care of that. So you fill that information in there. The next section is in the ordinance. You must now, in your complex, have a towing and relocation service. It is your responsibility if there is an abandoned, unlicensed, inoperable vehicle in your parking lot, it is your responsibility to have it removed, okay? You must have a written agreement with the relocation towing service, have it posted on your property that if you have an inoperable vehicle on your property, this person or this company will tow it at the owner's expense, okay? We also want a copy of the agreement that you have with that service, and it must be attached to the application. Okay. There are also, before you sign the application, you have certain assumptions that go with this particular ordinance. You know that by signing the application that you are obviously going to give irrevocable consent permitting the village and its inspectors to enter upon any and all portions of the licensed multifamily dwelling that is other than the individual dwelling units for the purpose of making inspections, okay, other than the dwelling units themselves. By signing the application, you give irrevocable consent and agreement to pay all the enforcement costs provided by the ordinance. That's the fees. Also, by signing the agreement, you give the tenants, you hereby agree to have all the tenants sign the crime-free multifamily lease addendum. Okay, and then the last thing is, if you perjure yourself or misrepresent any information in the application, we can prosecute you in accordance with law. The last page is obviously the signature page. We want signatures of all the owners. Like I said, if you have a trust, LLC, if you're incorporated, corporation, you have partners, every single one of them have to sign. Your managing agents, if you have those, they need to sign also, okay? So that covers the application.
Vicki.
So, in summary, one application for multifamily dwelling. It must be filled out in its entirety, okay? You're going to submit this with the fee to the clerk's office. They are not there to look through that application and make sure it is filled out completely. That is your responsibility. They are only there to take the application and the fee, all right? We'll get into the fees later. That must be accompanied with your application. We need the written agreements between the owners and the managing agents and the janitors that we talked about. We need a copy of your service agreement between the towing and relocation agreement service, and then all of the signatures, all right? We can go back to the PowerPoint. Okay, we're going to talk about fees. Thank you. It is sinus weather. Okay, per the ordinance, the fee is $30 per dwelling unit. So if you have six units in a dwelling, it's $30 for each dwelling unit. Obviously, that's $180 for your building. Pretty simple. Tried to make it simple. Okay?
Per year. Per year.
Per unit.
Per year.
Once a year. Okay?
Is that always in the beginning of the year, like in January?
Yes. If you complete your application fee and you don't have it turned in prior to January 1 of each year, there is a penalty of 20%. Okay? And that 20%, if you don't pay that on the first day of each subsequent month, it is also considered delinquent. Okay? We do have a provision. If you are, say, like Twin Lakes and you have over 100 units, you can pay it in 2 installments. You could pay 50% at the time you hand in your completed application, and that is the key, a completed application. If your application is not complete, that is not considered a submittal, okay? Very important that your application is complete. You can hand in 50%, and then the remainder must be paid before July 1. If it's not paid before July 1, that same 20% penalty comes into play. If the change of ownership happens during the licensing year, the fee for the new owner will be prorated, okay? There are absolutely no refunds. No questions about it, no refunds, all right? Detective Gabrielski is going to talk about the crime-free lease addendum. This is for your protection of your building, okay? In the ordinance, written leases are not mandatory. You do not have to have a written lease with your tenants. Though we strongly suggest you have a written lease, you do not have to. If you do not have written leases, verbal leases are always assumed, okay? Everybody occupying your dwelling, the age of 18 or older, must sign a crime-free lease addendum. Okay? Copy of it must be attached to your application. And from here, I'll let Detective Gabrielski, who is my partner on the criminal side of it, take it from here and let you know more about this and how other ways of the eviction process to assist you.
Is it all up there?
These are the slides.
Okay. Should I just go on to the next slide then?
Yeah.
This one? Yeah, push it. That button? The slides that I'm about to go through is what you, as a landlord, has as power to evict somebody or get rid of them. The one section, the state statute is 765 ILCS 705/5, lease addendum for drug-free housing. If somebody commits a Class X felony on on the premise, if they're arrested for that, you have the right to evict them immediately. Probable cause at a preliminary hearing or grand jury indictment is enough to have somebody evicted right away. Most of the landlords don't think that they have rights, okay? As you're going to see right through here, this is what gives you the power to evict somebody right away. Lease becomes void. Posting notice on the premise to vacate within 5 days. Must contain basis on clerk of court form. In other words, it can't be on word only unless it's from a law enforcement official or if it's in the court dockets. That way you have the right to evict this individual. It can't be just hearsay. May bring forcible action, no forfeiture of security deposit. No cost to the defendant unless suit brought in bad faith. Okay, eviction basis on drug activity. If cannabis, narcotics, controlled substance are found or used anywhere on the premise that the substance were used or possessed by a tenant, occupant, or that a tenant or occupant knew or should have reasonably known that substances was used, possessed, can be basis for eviction. I've been calling up and working with a couple of the landlords. What's going to happen I'm going to continue to do that. If there's a Class A misdemeanor or more, in other words, a felony or Class A misdemeanor, you're going to have to evict that individual. I'm going to call you up, say that an individual is arrested on your premise, and that person needs to be evicted immediately.
They don't have to be convicted.
They don't have to be convicted. It's the presumption that the stuff is there, that the owner knew it was there.
I thought the presumption was innocent until proven guilty in this country.
You're right. You're right as far as criminal law goes. But if the person has that on the property, they have the right to be evicted.
Okay, and again, this is being recorded, so please, we need to hold the questions so that everybody can hear what your questions are on the tape, and then we can get the answers so that everybody can benefit from your questions, okay?
The next slide, leasee or occupant on one or more occasions uses or permits the use of the premise for the commission of a Class A misdemeanor of a felony in Illinois, and the landlord has the option to hold the lease void. The leaser may recover possessions from the premise from the tenant if the tenant was holding over after expiration of the lease. The tenant does not forfeit security deposit. A judgment for possessions rendering under the provisions may not be stayed longer than 7 days unless the parties agree to a longer period of time. Next slide. Alternatives to eviction: don't renew their lease if it's expiring soon, and enter into a mutual agreement to dissolve the lease. Service and notice: use correct forms, fill it in correctly, time it accurately, serve it properly, hire an attorney to make sure it's done right. This slide here is an example of a 5-day notice that can be provided to you by Wheaton, out in Wheaton, the clerk. I don't know if you may have your own form, but that's the verbiage that it needs. In that form, you have a copy of that as well. You can print up your own copies if you need to. 10-day notice to quit. You are hereby notified that in consequence of your default here in the interest of the character of the default of the premises now occupied by you being, etc., I have elected to terminate your lease, and you are hereby notified to quit and deliver up possessions of the same to me within 10 days of this date. It's a 10-day, that's telling them that you want to quit the lease and that it's no longer going to be, it's giving them notice. It's not an eviction. It's just that you are no longer going to renew their lease, giving them notice, written notice.
So what he's given you now is not only can you evict someone based on the crime-free lease addendum, he's given you some state statutes that you can use as a tool to also evict problem tenants, okay? And this last slide here, this 10-day notice to quit, is a notice that you would give someone if you choose to terminate someone's lease, all right? If it's not even a crime. If you have a problem tenant, you don't choose to renew their lease for some reason, they're not paying their rent, they're trashing your place, or whatever the case may be, that's a tool to use. That's some of the proper verbiage to use. If you go through the eviction process, it's strongly recommended, unless you've done this many times and know the process, because if you don't follow the correct timelines, use the proper forms, the judge will throw it out, okay? Use an attorney unless you are positively sure you know how to evict a tenant, okay? And like I said, in the next 2 meetings, our village prosecutor that does code enforcement will be here, and she can go into more detail to help you as landlords, because that's a very important, I think, a part of what you do as landlords, and a tool for you so that you can keep your properties maintained for any problem tenants that you may encounter. Okay? All right, let's talk about inspections. In the ordinance, we will inspect your property. We will make every effort to do 1 inspection per year of the exterior and common areas of the building, if you have common areas. We will conduct a minimum of 10% of the interior dwelling units, and that's a minimum, okay? If we choose to do more than 10%, we will. Chances of that, with the staff we have, will probably be pretty slim, but we will make every effort to do at least a minimum. We will provide notice. We provide notice to the owner or the managing agent, at least a minimum of 7 days of when we're coming to inspect your exterior of your building and your common areas. We will also notify your tenant a minimum of 7 days of the dwelling unit that we are going to inspect. So you will get notice of when we're going to do the inspection. You've been given copy of the inspection list. It's not inclusive, okay? But it's going to give you a general idea of things that we will be looking for. It's pretty comprehensive. It starts from the outside, it goes in, and even into the dwelling units. It's a good tool for you to use, all right? It's in a question kind of a thing. Take a look around your building. Use that as a tool. If you have questions on one of them, give me a call. I've tried to put code sections in there regarding those particular issues for you to look up if you need to. As previously discussed in some of the public forums, a tenant can deny the right of entrance for us to do an inspection, okay? If you have 6 units and all 6 tenants say you cannot enter my facility, this ordinance gives us the right to do a minimum of 10%. We will be forced to go get administrative search warrants. We do not want to do that. We want to get the cooperation. That will be a last-ditch effort. But if we have to, we will get an administrative search warrant to perform our inspection. Okay?
This is for questions. Give it to the person.
Also, the inspectors that will be performing these inspections will be International Code Council certified property maintenance inspectors. That means that we have taken a test, a certification test. We are certified in our line of work. Also, the inspectors will have an identification on them. Looks like this. We will be carrying this on us at all times. If you do not see this on us, okay, ask to see it. If there's a person around your building and doesn't have an identification, tell them to leave or call the police, all right? We will have this identification on us. Very important, okay? All right, you've got your copies of your inspections. The first inspection that we do is part of your application fee. Okay, that's included in your application fee. If we have to come back out and do a reinspection, there will be a reinspection fee of a minimum of $50. That's $50 an hour. Now, we've done a couple of complexes, okay? And I can tell you that I have never spent more than an hour doing a reinspection. I'm telling you that it may happen, it could happen, but I've never spent more than an hour doing a reinspection, because basically going back to check the reinspection list, okay? If violations are found when we do our initial inspection, we'll send you a violation letter. It'll go to the owner or the managing agent, whoever you choose, or we will probably send them to both. We'll give you a date certain to rectify those violations. Upon reinspection, if they're not rectified, we will have to go to the citation process. We will serve citation on the owner or the managing agent, and then we go to court. We will give you plenty of time to rectify these situations. The last thing we want to do is go to court. It wastes your time and it wastes our time, okay? We work with you. I believe that in the complexes that we have been in, you can talk to them. We've been in the ponds in Willow West. They can testify to you that the majority of them, we have worked with them, okay? Our goal is compliance, not to take you to court, okay? If it does go to court, you can be fined anywhere up to $750 for every day the violation exists. You can be placed on court supervision, and/or your license could be suspended or revocated, okay? That's if, all right? That is if you go to court. All right, there is an appeal process. If the village suspends or revokes your license, you have the right to appeal. On the back table there, I had a form, an appeal form. It must be in writing on that form, and you must either hand deliver it to the village or mail it through first-class mail to the village within 30 days of your suspension or revocation. The village will schedule a hearing. It will be held in this building, in this room, and we will give you a date and time certain, and we will notify you a minimum of 7 days prior to that date. You must attend and present your appeal in front of the board. Now, the board is consisting of three members, okay? There will be a representative from the village, there will be a tenant, and there will be a landlord on this board, okay? It's a very diverse board. They will hear your appeal, and after that appeal, they are given 5 business days to make a decision of whether to approve your appeal or deny it, okay? Once they come up with their decision, they will mail you by certified mail what their decision is. All right? If you choose, if, say, you are suspended or your license is revoked, you choose to pursue it further, you always have the court of law. Get your attorney, and you can go further through the court system. That's the appeal process. Okay. Are we ready for question and answers?
Yes. This is how this is going to work. We're going to pass around the microphone to anybody who has a question. Once you ask the question, we're going to repeat the question up here and then answer your question.
All right, we're going to try every way we can to answer your question as best as we can, okay? Again, this is our first meeting, and we are learning from this meeting, and we will probably learn more based on your questions so that we can better the next meeting, okay? If there are questions that we cannot answer, we are going to write them down, which is why I wanted you to write your names and addresses down. We will get the answers to those questions, and we will mail those to you, all right? So please keep your questions to the information that was provided today, all right? We've already been through the public hearing process. This ordinance is on the books now. So if you have questions about the appeal process, about the application, about the inspections, or the crime-free lease addendum, we'll be happy to take them now.
If you have a crime-free lease addendum currently, which we do at our complex, can you use that, or must you use this one that is used as an example here, or must we use this?
As long as it has the same language in there, you can use that, yes.
I have two questions. My first question is about the managing agent. According to real estate law, a managing agent should be a GRI. Now, my question is, with the village of Westmont, do you require my managing agent to be a GRI, licensed real estate?
No. A GRI is a real estate agent.
Yes, to rent out my property and to manage it. That's what a GRI. Now, your managing agent, can it be, my question is, can it just be a handyman that he just maintain it?
It can, yes, a managing agent is basically a handyman or someone that you choose to oversee your building.
Okay, so not necessarily
on a daily basis.
GRI.
No, it is not a GRI.
Okay, thank you. Now the second question, relocation. Is it a must that I have a relocation?
I'm sorry, repeat the question?
The relocation, the towing company, is it a must that I have to hire and post there and pay the dues for the relocation?
Oh, the relocation
Yeah,
towing
the towing
service?
yeah, service.
Yes. You must get a relocation towing service to tow any abandoned vehicles that are in your parking lots or on your premises. And then you get a sign, and you must post the sign. And what that sign will say is, any abandoned vehicles, and you'll see them throughout. Most of the complexes have them already. It's got the name of the company, and your vehicle has been towed at your expense, and it gives the address and phone number.
So we cannot use the Westmont police anymore? Because right now we have a sign there that, illegal parking. I just called the Westmont police because we have an agreement there. And then the police will come over and issue a ticket. The police do not tow it, but the police issue a ticket, even if it's a private property. So you're telling us that we cannot use that kind of service anymore?
The police department can issue tickets. They cannot tow vehicles.
Yeah, they don't, yeah.
Okay? It's your responsibility to tow that vehicle.
Okay, all right.
Okay?
So that won't work anymore. It must be a relocation company.
Yes.
Okay, all right, because that's an extra
Let me clear up
expense.
some misconceptions. Relocation companies cost you $20. And the $20 is for the sign that needs to be posted up there, okay? That's it. They'll hook the vehicle, they'll take it, and everything that, all the costs after that goes to the owner of the vehicle, okay? If they never recoup anything from it, then they crush the car and they get a junk title, and they make their money off of crushing the car and selling the parts and stuff like that. So it's gonna cost you $20. I believe it's every 200 feet that a sign needs to be posted to get a vehicle off of your property. And it's one-time fee, $20. Pardon me?
Some do it for free. Our towing company, there's no charge at all.
Okay, so what you said is some companies do it for free, and your towing company, okay.
We're splitting hairs with towing companies and relocations. Relocations go in there, they do it for free or $20. A tow company is someone that you hire to come in there to take it off of there. So you're splitting hairs here, but if you get a relocation, and there's not that many out there, there's only a handful of them, okay? We're not gonna recommend any of them, but you can look them up and ask them if they're a relocating service, all right? The relocating service will do it. The one that I know of is $20 for the sign, because they have to post a sign up so that the individual as their vehicle towed knows where it's towed to, okay? We're gonna try and, I seen this young lady here first, so.
In regards to the janitorial management, that refers to basically if you've got somebody hired on a regular basis. It doesn't refer to like handyman service people that you're using within the building. Is that correct?
It could be. It could be.
Well, I mean, like, you know, when you have furnace repairman, service people like that, or if I have to have some work done within the apartment, I just kind of use a handyman, and it could be a different person.
Yes, it could be. If you don't have a managing agent that you give the authority to say hire, say you use a plumber, a certain plumber, or you use a carpenter, and you use a HVAC person, we don't want their names, but if you allow your managing agent, or say you have someone in your building that you give the authority to make those phone calls, say the boiler goes out, we want that person's name and address.
Okay, I just wanted that clarified.
Yeah, because
Also-
because you, as the owner, are giving them the authority to call that repair person to make those repairs.
Okay. Also, another question in regards to that prime freight. If my understanding here is an officer of the law has to basically be informed, or we have to have notification that they have been. But what if we know for a fact that someone is dealing or you know, having drugs within the apartment? What recourse do we have?
Those state statutes that were on those slides give you the authority to evict someone from a dwelling unit. And Detective, you can correct me
Yeah, but my
if I'm
question
wrong.
is, you know, if we know it,
Do you understand? What I do is criminal. I arrest people. What you do is civil. So if you have a basis to evict somebody based on you seeing drugs and stuff like that, you have the right to evict them. That's civil. Okay, so you don't have to go to the high level that I need to go
Lenny, you need the
in order
microphone.
to arrest someone. Okay? It's a civil matter. So you have the right to evict somebody once you see that going on and you document it. That way, if it's ever brought back to you, you could say, on such and such date, I took a picture of it, here's the items that I found there, that's why I evicted the person.
well, of course, I'm referring to, like, let's say the neighbor tenant is saying, hey, we know that they're smoking pot.
Right. Well, knowing something is different than actually seeing it and enforcing it.
So you actually visibly have to see it yourself.
Correct.
So you're saying that the neighbor sees the action taking place, can you use that information to evict? Detective?
Call the police and then give their authority behind.
Correct. Call us, okay, and we will go and investigate the matter.
Because I've had situations like that, and it's like, well, how do I get these people out?
There is the ordinance, the statutes provide a 24-hour notice where you don't take any action, give the person an opportunity to leave and to vacate the premises. It's in 705 or 735, and it's a 24-hour notice. It's got the verbiage and everything in there, giving, where you have no conflict with the person. You just give them notice, give them an opportunity, before you contact the authorities.
Your other remedy is if you have a written lease, terminate their lease, put some verbiage in there. There's no law that says that there are certain things you cannot put in your lease.
The only reason I question that is because I've consistently had that drug-free rider attached to my leases, and I have had problems where I know, that people are in drugs, and it's like, how can I, how much strength do I have to do anything with
Your
this?
strength exists, okay? The person, your tenant calls you up and says, the neighbors across here, okay, are doing something illegal, okay? You don't have to have a reason, this is the gentleman was trying to say, okay? You could serve them with a 10-day. If you're terminating their lease, okay?
Okay.
It's as civil matter, you have more rights than we
Oh, okay.
criminal.
Oh, all right.
Yeah, I have a question about the inspections. There was, you said they're going to be done in like timely manner and, you know, minimal, so we can, you know, save the money. But I have experience, I think it was you 3 years ago, and you gave us a list of violations. We fixed that. 2 weeks later, you came up with a different list. We fixed that. That repeated several times. Then finally, we didn't fix that. We ended up in court. So how this is going to be done in the future?
What the way that this works is, we do an inspection, we give you a violation letter. It notes the violations, and then it gives you another section that tells you what you need to do and how to remedy that situation. In the next paragraph, it tells you a due date of when those situations must be rectified and when we will come back to do the reinspection. We will come back, do a reinspection. If those certain items, if some of them were done, that's okay. If some of them are still remaining, you will get another. And in the particular case, I'm assuming you were in one of the first complexes we went to. We were giving a second notice out, a final notice that gave you additional time, and it was repeated because that particular violation had not been corrected yet.
No, this was not repeated. This was totally different violations you find in second inspections when we fixed the, you know, second letter of yours. Then you came up with another different type. I have the letters. I can prove it. I can bring it to the village. And then we ended up in court. So, I mean, you came up with different hardware on the, you know, on the railing or some silly things, really, that doesn't have anything to do with safety or, you know, anything like that. So,
okay, I'd be happy to talk about that with you, because that would be an individual thing, a specific case.
Okay, I'll show you the letters. I called the village several times.
I'd be happy to discuss that with you.
All right, and another question, like if the village want to, you know, take the control, would the village be willing to, you know, buy the building from me? Because in this economic situation and with this attachment to it, nobody will be able to sell their property. So would the village, if they want to gain the total control, I'm more willing to sell the building under the market price, and, you know.
The answer to that question is no. We're not willing to buy your property.
Okay, and that's very well.
Other questions?
Thank you. My question is on this towing service.
Quiet, please, so we can hear.
My question is again on this towing service. I have a 4-flat. There's 6 parking places. I know who parks there. Do I have to hire someone, have to post a sign? I know my tenants. I know whose car is there. I've been a landlord for 52 years. I know how the hell to handle it. Why are you doing this? Why do I have to have a towing service? Why do I have to have a relocation service? If somebody illegally parks in my parking lot, believe me, I will get a ticket on them and I will get them taken care of. I see no reason why I have to do this ahead of time, when I'll take care of it immediately when it's necessary.
That is part of the ordinance. It is required, and I can tell you of an instance where we've had a building that has exactly the same thing. It had 6 parking spots, and it had 2 inoperable vehicles. And finally, it took, after 2 months, that owner to hire a relocation service so he could get rid of that vehicle.
Well, okay.
Because legally, he could not remove that without the title to that vehicle, legally.
Oh, I understand that, but you do it when it happens.
That is part of the ordinance. Yes, you do need to get a relocation service.
Okay.
Next question? Or do you have another question?
I do. On this crime-free addendum, can we just use your form and have our tenants state and sign it?
Yes.
Yes, ma'am.
Okay.
And feel free to copy that as many times as you need to.
Thanks a bunch.
Thank you. Next question?
I own a building in the Willow West complex, and we have an association. And my question is, what role the board at Willow West will play in this whole scenario? And the reason why I am bringing it up, you indicated when we apply for the license, you need a copy of the towing agreement, you need a copy of the alarm inspection, the company who serviced it. I don't handle that. the board signs the contract for both. So can you place one file somewhere, one copy of the contract somewhere in your files for all of the Willow West owners? Because I cannot attach a copy of these agreements to my lease application because I don't have it.
Do you own the complex?
I own a 4th flat in Willow West, but we have a board of directors
Okay.
who sign an agreement for towing, for fire alarm inspection, etc.
You would get that from a copy of that from the homeowners association.
I know you were going to say that.
Right.
I do want to compliment the village about the inspection. My building was inspected. We had some medical emergencies, and you certainly cooperated with us, and we passed your inspection last year. On the other hand, I still don't know what we're getting for that fee that we're going to pay the village. I have a 4th flat. I do the crime-free addendum. I do, before I sign a lease with the tenant, I do a background check on them. I was kind of surprised that I didn't see that anywhere in your ordinance. So I am really not getting anything from the village because I have been doing all that you have put into this ordinance. So I am basically asking you, what am I getting for my money? When I had a drug-related problem, I wanted to evict a tenant. I had the addendum. I had to hire a private investigator to catch the person with the drugs, and then I hired the attorney to evict them. So I am really looking for support, just like that lady asked you the question. But she really was, what I understood, she didn't have a drug problem in her building. There was a drug problem in someone else's. She cannot evict that tenant from someone else's building. So how do you help? Thank you.
Well, let's try to answer your question, ma'am. It's a very good question. What are you getting for the fees that you're paying here? We think you're going to get a level playing field with the other landlords. We applaud the people that are here today. For the most part, you all do a fine job in maintaining your properties. But just like everything else in the world, some people don't do a good job, and they make it difficult for the people that do observe the law. We do unfortunately have landlords that don't maintain their properties in a safe and code-compliant manner. In order to require them to do that, the village board had to pass a law that applies to everyone. Aren't you kind of tired as a landlord in seeing your tenant stolen by somebody that offers lower rents because they don't maintain their building and they can charge people less rent, and that takes tenants away from you? Don't you want to level the playing field? And that's what this law is designed to do, to make sure that all landlords meet minimum code and safety compliance standards for their buildings. Overall, for all of the people that live in the village of Westmont, that upgrades the housing stock and the rental dwellings that we have in this community and makes a better quality of life for everyone. That's what you get in exchange for the fees that you pay.
Thank you for that explanation. I think people have to be aware of why the village, is basically doing this for us, because I've owned buildings here for 35 years, and actually I've seen things take place here. And like you're saying, some people just don't take care of their properties, and it's like, what can we do? You know, I'm very conscientious of everything that I do in my property, and it just costs me.
All right. Next question.
I have a question. On the application, you mentioned, my question is probably will be directed to Mr. Kimball. You're asking for a copy of the fire alarm information, the towing company, and how many other than that drug-free, are there any other forms that we have to submit?
I believe, Vicki can answer that question.
Right.
Oh, okay.
We'll need, if you have a managing agent, we'll need your written agreement with him or
skip
whatever.
all the managing people.
Okay,
I'm just talking about outside sources, like garbage contracts, because in the ordinance.
Right, the relocation service agreement, your fire alarm agreement, or, yeah, the fire alarm.
Then my questions, the next step of it is, this is why I wanted you, Mr. Kimball, is on large complexes, let's say Willow West, Willow View, the Ponds, and others, couldn't we have a general ordinance information, or from the office, the managing office, or I would just call it an office. What do you call it, a managing office or what? To give you, for that complex, like the Ponds, we have about 80 owners. So in other words, we're making 80 copies, and it's more paperwork for you, and blah, it's just additional paperwork for everybody. We're, excuse me, and we're not keeping the country green.
Well, we'll try to work with the HOA and the managing entity for the large complexes like that. I think maybe what we can do is we can just, by maybe having some individual meetings with them, is say, you know this is coming, and it would behoove you to have copies available of the following things: the agreement with the fire alarm maintenance company, the towing and relocation company contracts or agreements that you have in place that apply to all of the units within the Ponds, within Willow West, within other large-scale complexes, to make it easier for you to attach that information to your application.
Well, what I'm trying to say is, why can't we give the city of Westmont one contract and explain it's for all the buildings in the Ponds or Willow West or Willow View or other large complexes?
We'll talk to our village attorney and see if we can work something out in that regard with you, because I applaud your desire to save on the number of copies, but we still want to make sure that everybody's in compliance. We'll try to work with you on that, and we'll take that question to our village attorney. I would definitely like this followed up. And then my next question, going back to Vicki, is who reviews these applications?
Me and my staff will review the applications.
Okay. And that would be reviewed in a normal period of time?
Right. When we get them in, we will be reviewing them, and then we will be putting into a computer system. Okay. One thing I don't know if I addressed, if there are any changes in addresses, phone numbers, or contacts in your application, you need to get that information to us immediately, like within 7 to 14 days. Okay?
Well, thank you.
Yes, I have a question about using illegal substance in a buildings. I don't know, but if you know, the country is changing lately, and last time I heard on an NPR that new administration signed a law using cannabis for medical reasons. Let's say that this is a situation. Somebody, I have a building in 608, but somebody is using marijuana for cancer or medical reasons. Now, people complaining. I'm going to be complaining over there and tell them, hey, you're smoking marijuana, it's illegal. Now, we know in this country, lots of people, if some crime happened, 50 people goes by, and you see that last time when the lady was raped by 20 students. So I don't know, because I work for the lady, and instead of address, she got a P.O. box number. So I don't know if I should say something. I would call the detective, a police, hey, go investigate over there. But I don't want to get in I have a family, I have something like that. I don't want to, be like saying somebody, there's a marijuana over there. I say, hey, I'm smoking for medical reasons. I don't know if the state of Illinois already passed the law, but it's, maybe you can, as an attorney, answer the question to it.
Sure.
So how are we going to be, controlling this kind of situation?
Same way we would do everyone. We investigate it. Okay? For the one person that's smoking it for the legitimate reason, we'll take that into account. For the people that are smoking it illegally, then they're going to be arrested and evicted.
But if you're gonna, you don't know if the person smokes, okay, but it's very touchy situation, because I mean the hard drugs is different, but you go with some bars or some place, and you can smoke the marijuana on the streets or everywhere, especially young people, every Westmont, everywhere in these bars,
Yeah. Did I answer your question?
Yes.
Could you give the microphone to the lady next to you, please?
Okay.
Thank you.
I'm just wondering if my property is maybe a special case. I don't know how much subsidized housing is here in Westmont, but I manage a subsidized senior property. And of course, it's regulated by HUD. And any addendums and attachments to the lease, they have to approve those. Additionally, they come out every so often and they do their own inspections on top of our inspections. So I guess my concern is whether there's going to be a conflict somewhere.
Can you tell us
Which complex?
Eye Care,
Eye
501
Care?
Cass Avenue.
They would fall under this, but I believe that they are they exempt from the fees? I believe you're exempt from paying the fee since you're a federal, you're funded by the government.
Correct.
But you would still have to use the crime-free addendum, which is the same one that HUD uses. It's the same language.
Okay.
So you're probably already doing what the ordinance is asking.
Correct. And then the inspections, are we going to be subject to your inspections?
You
as
will
well
be
as
subject
theirs?
to the inspection, yes.
Okay.
Thank you. My question was just about the 7-day notice and how the inspections are going to be done in the units. And that, I mean, I understand we need to inspect everything else. The part of this whole thing that I just have difficulty understanding is the part where they're coming into a unit that's occupied by people at this time. I know some towns do it when they turn over the unit, when in between one tenant to the other, they'll come in and make inspections, and the owners have to make upgrades at that time. And they're fined if they don't call for the inspection or have people come in. I understand that. I just have a problem with coming in, so this is probably, you know, could be any of the three of you. What's legal as far as coming into someone's house on a 7-day notice? I just don't understand the legality. I'm not saying it isn't. What's it, on a 7-day notice to say, I'm going to come into your house? How would that fly with you, officer, or anyone?
Here's,
you know? 7-day notice, I'm going to come into your house and just look at other things, plumbing or what have you.
let me give you a scenario. You live in a dwelling unit in a multifamily dwelling. I'm going to send you a notice and say, I don't know your name, dear Mr. Smith, on such and such a date and time, we would like to come and inspect the interior of your dwelling unit to make sure that it is up to code in accordance with the Multifamily Licensing Act. That date we come, we knock on your door, you answer the door, and you say, no, you're not coming in. Okay, thank you, we'll see you later. That's how that works out. Now, we will try to attempt to go to other dwelling units and see if we can get in there. Like the scenario I said earlier, if there are 4 units in there and we get the same answer on all 4 units, we will be forced to go to the court in Downers Grove, get an administrative search warrant. Then we will come knock on your door. Mr. Smith, we're here to perform an inspection on your dwelling unit. You say no. We're going to say, I'm sorry, Mr. Smith. We have an administrative search warrant that says that we can come in here and do an inspection. And it will list out exactly what we're looking for. It's just like any other kind of warrant, but it's not a criminal warrant. In other words, we're not in there looking for criminal activity. We're in there looking for specific code violations. It's very specific, and it's non-evasive. We can't come in there busting down your door, okay? We can't toss your house. We're just in there to look for the code violations, do a regular inspection. We don't want to go that route.
And that's really just your interpretation of mine and what you consider non-invasive. Many people think that having a stranger come in their home is an invasion. You know, especially someone, regardless whether they gave them a week's notice or not, to just come up and knock on the door. Now, when you're saying this about a week's notice, I'm just curious how it's going to work, because I understand when it comes to warrants and things like that, I'm sure you've got all your T's crossed and I's dotted and you're within the legal rights to do that. I don't want to get to be that far. I just want to get compliance, however we're going to do this. If you're going to give a week's notice, are you giving me the week's notice or the tenant, or who gets the week's notice?
We're giving you the week's notice of when we are doing your building and common areas, and then we are giving the tenant notice. Now, the 7-day is a minimum notice, okay? We will be giving more than 7 days, I can tell you that right now.
And so we can pick any unit that you're going to come and see?
We pick the units.
I've just got a 4-unit building.
We pick the units, and they will be random. Unless, as a landlord, you say, you know what, I haven't been in this unit for 10 years. I'd like you to inspect this one for me.
You really think you're having a problem with somebody who you've been paying the rent for 10 years? That's my point. I've got long-term tenants. We cleaned up our building already. It was a problem 20 years ago, and you guys weren't doing it, and we cleaned it up.
Then what your building will probably be the one that will do the minimum 10%.
What happens, so will you ever come by and not give a 7-day notice and just come in, use the Knox box key and just come in?
No, the ordinance states I must give you a minimum 7-day notice.
Well, it just happened last month to me because somebody came in and inspected my common area using a Knox box that I just put in because of the ordinance, never received a notice, never received anything else. That's
part of the Safe and Secure Westmont program. This ordinance now...
Oh, that program, okay.
Right.
Sure.
This ordinance is taking, this is pretty much going to take place of that program.
So what you're saying, 1 unit out of 4 would be satisfactory to you?
Yes, be 10%.
So I'll just, I'm just trying to be clear. I'm not. It's just that all of a sudden there's another reason or another thing, and I understand the legal part that once we sign this lease agreement, we pretty much give up our rights to you, and you can pretty much do anything you want after that. So that I understand. You say that there's legal things we can do after that, and really, I think it'll always come back to that lease agreement and go, well, you signed this, sir, and then that'll be the end of the legal part.
Well, actually, it's not that we can go in there and do anything. The administrative warrant, and I don't like to say search warrant because it's really just an administrative warrant. It specifically spells out in there what I can be looking for, okay? It's specific. It'll say I'm looking for leaking plumbing fixtures. I'm looking for electrical fixtures that are, electrical outlets that aren't properly GFI'd. It goes into detail as to what I can be looking for, okay? I can't just nilly-willy go in there and look through dresser drawers, stuff like that, okay? So it's specific, right. It follows pretty much your inspection, the inspection form that I gave you.
Okay, thank you.
Okay.
I was just wondering, one more, just about the re-inspections. When you come out and inspect once, I just want to make sure I'm understanding this right, and you find I have a fire extinguisher that's expired, and then you come back to check to make sure that it's not expired, does that cost me $50, or do I get one re-inspection, one time come back, and you say, yes, okay, I'm in compliance and everything's fine?
The ordinance says yes, it's $50, okay? But I believe in yours, your association takes care of the fire extinguishers, is that correct, or are you responsible for your own?
No, it's just a little building. I'm responsible for everything.
Okay, then yes, it would be a $50 re-inspection fee. We got some questions over here, or over here, okay.
I'd like to know why the town of Westmont, the apartment, how much percentage of apartment buildings are in Westmont? 20%, 25, or what?
We think it's closer to 55% of the total housing units in the
So
village.
what you're basically saying in this ordinance is that 55% of the people have got to be scrutinized, but the other 45% that live in homes or townhomes are perfect. There's no crimes. There's nothing wrong with their homes. Their decks ain't falling apart. They're not doing marijuana. They're all perfect. Let them alone, but attack us. I don't think that's fair at all.
Okay.
I think if you do something for one, you do it for the whole.
And we understand that. And
Right.
I think there's been a discussion among the village board at public hearings that indicates that if this program gets up and running and we're able to do this effectively and elevate the level of housing stock in the village of Westmont, that we may end up inspecting rented single-family dwelling homes as well as multiple family dwelling homes.
Well, that may sounds good, but it might never happen.
Okay.
I think it's going to happen sooner than you think.
And a second question, when you have the right to go in apartments, I know you want to give them 7 days and all this stuff, and you'll break your heart and even give them more than 7 days and all that. But I want to know one question from somebody in this village. How in the world we have a federal ordinance, we have a federal law for privacy. How in the world does a city ordinance supersede a federal law? I want somebody to explain that to me.
This is to promote the general health, safety, and welfare of the general populace of the village of Westmont. I would point out to you that our ordinance is modeled in some ways after ordinances in the village of Woodridge and Palatine. Excuse me. Both of those villages have had their ordinances on the books and operational since the early 1990s. Both of those ordinances have withstood successful constitutional challenges on a number of occasions. I believe in Palatine, the village staff in Palatine told us their ordinance had been challenged on 4 separate occasions, and the courts have held that their ordinance is legal, that they do have the right to do that to ensure that minimum code conditions are met throughout their community.
Okay.
It's been time-tested over and over again. Big cities, the city of Los Angeles has been tested numerous times in courts of law. Their ordinance is valid. They go in and inspect the interior of rented dwelling units.
So what you're saying, there's no uniformity between federal, state laws or ordinances. They overlap each other here and there, and there's something to be done about it, right?
The ordinance that we have adopted covers and meets all of the constitutional amendments, and it's been upheld in the Supreme Courts, and that's what we're standing by. Does anybody else have questions on the information that we presented today?
On that administrative warrant, I mean, this is just something after I heard you talking. Does a policeman come with you?
Yes, sir.
Okay. Now, if he comes with you and he sees a AK-47 laying on the sofa, it's in plain view, he has the duty to arrest that person or do whatever. Am I right or am I wrong? I'm just curious about that.
Well, everyone has the right to bear arms. We have to first check to see if they have a firearm.
Well, I mean, if he saw drugs there, I mean, you got the right, if it's in plain view and you're going in there on another matter, you do have the right to enforce the law.
Let me clarify
Right?
that. It's not on our search warrant.
No, it's not on your search warrant,
He
but
would
if
have
it
to
was
go
in
back.
plain view, it would automatically become an issue. Yes or no?
He would have to go back and get his own search warrant.
Okay, but he could do that. He could do that. Okay. Now, my
possibility.
question here is, we started out with no alarms, then we jumped up to alarms. We all complied. They said this is the last time we're going to have them. Any problems? I'm sure we're going to go into smoke detectors and all this stuff. Now they're trying to get us to go to Norcor, which is going to cost a lot of us money who already have a wireless system. My question is, I'm hearing that when the village made a contract with Norcor, they're actually going to get a kickback from Norcor. So if the fee to us building owners are $60 a month, Norcor is going to get a portion, there's going to be a portion for services, and then the village is going to get back like $20 a unit or $50 a unit. I'm just wondering, is that another tax? Is that another fee? Is that a way to slip, get more revenue for you guys? And I just don't understand that. I'm just wondering if that's right.
Norcom is the company you're talking about. They're a wireless provider. We could have used any one of numerous wireless providers because all the towns around us that do this have different providers. Norcom offered the best deal for the residents, which is what we were after. It wasn't a deal for us, it was what we were providing for the residents.
But do you guys get a kickback?
We get $5 per subscriber, and that's to maintain the equipment in our dispatch center.
$5 is...
$5. It was the best deal at the time that the contract was signed. I mean, let's back up. I wasn't in my position at the time.
Okay.
It was open for bid for contracts.
How many bids you put?
I have no idea. I wasn't involved with it.
Okay, that's on the, yeah, we're talking about the landlord licensing ordinance here, so let's get back on track here.
Moving on, the application you say is going to be reviewed by,
Be by my division, yes, Code Enforcement Division.
As in any agreement, there may be things in there that we may not agree with. So if I don't agree to the irrevocable consent, because it imposes on my rights, it's a given that everybody gives consent to an ordinance and will abide by the ordinance. And I don't feel that there's a necessity here to go beyond that. And it's been shown in other cases where the agreement like this gives the village an opportunity to shortcut the process, the due process portion of this. And that's why when a police officer comes with the inspector, they don't come with, they don't notify anybody of a hearing or give anybody an opportunity to just say, hey, look, you know, I was working, I'm sorry I wasn't here, you know. People do work, and that's where we're going to run into problems. A greater percentage of the people that live in this town work. So when you do your inspections and people aren't home, they're at work. And this is where we're going to have a problem. And so if I don't agree to the irrevocable consent, I'm going to give you consent. Everybody, it's a given thing. People agree to abide by an ordinance. It's just the irrevocable portion of this that it's deceiving. And we don't understand. It's not an understandable term, just where our rights fall within that line. And if I don't agree to the irrevocable consent, would you reject the application?
That would be an incomplete application.
That would be an incomplete application.
Will there be a process
Correct.
necessary for us to go through, like an actual judgment by a court to you know?
It would be considered an incomplete application, and then our attorney would decide how we would deal with that application.
Okay.
And then we would either suspend it, not allow it, revoke it, and then you have the right to appeal.
Well, just even the Miranda rights, people are given an understanding, and to me that irrevocable is not an understandable word. We don't understand it. Just what does it mean?
You don't understand. You don't understand what that comment means fully.
I don't understand
Okay.
where it will take me. That's right.
Yeah. Let me tell you what we'll do. We will get a written statement from our legal counsel, and we will send that out for you from all the addresses. So make sure you know that notebook I sent. If you want a copy of that, we'll mail the answer to that question.
Definition of irrevocable consent.
Okay.
Yeah.
Is that agreeable to everyone? Okay.
Well, so that we understand what we're getting ourselves into here.
Very good.
You know.
We'll get more clarification for you on that and mail that out to everybody.
Okay. And another thing too is just for public information, you have a list of all the known landlords in Westmont. Is that listing available under the
Actually, we do not have a list of everybody who rents.
Well, I got a letter, so you must have a list.
We have some, yes.
That list is certainly FOIable. We'd be happy to,
Well, that'd be great.
if you don't fill out a FOIA request, we'd be happy to give you a copy.
Well, that'd be great. I appreciate it. Thank you very much.
Where's the microphone at? We're moving our way forward, so we'll get to you.
Thank you. I have a couple questions about this inspections.
Yes, ma'am.
And that one is the residents, and that are they going to be required to move away bed furniture, dressers, to get to outlets, empty out the bottom of their kitchen sinks? I mean, will they be required to do all this? If we don't, can they?
I don't foresee that happening. Obviously, we have not done the inside of a dwelling unit unless you've got someone who is a hoarder to where we can't, get to something. I don't foresee that happening, no.
Okay, does the...
Now, obviously, if I open the bottom of the kitchen sink and I see everything's drenched with water, I'm going to see there's a problem there. I might cite that. I'm not going to pull everything out to find the situation. I may just say, hey, we have a water leak underneath your sink.
Okay, if you're going to go into an apartment and, as one gentleman said, what if the person's working? Is management going to be required to open the door to let you in?
I believe we're going to make it the policy to have written consent from the tenant to go in there if they're not going to be home.
Okay, but management would have to give you the key then to get in.
That is correct.
Okay, and the last part of this is like vacancies. At one time I had heard that if a unit was vacant before it was to be rented out, it needed to be inspected. Is that part of this?
No, ma'am. No, we're not going to do that.
Okay, thank you.
I kind of stumbled here at the start when you talked about this law only covers 75% occupancy.
70% occupied by rental units.
Oh, by rental unit, not occupancy of people in a rental unit. I mean, say you had 16 units in it, and you had 5 vacancies. That would be less than 75 or 70.
Well, it depends on whether they're rental units or they're
Okay.
owned
you're talking
separately. Are you talking about condos?
No, I'm talking about rental units.
Okay, if they're vacant, they're still considered rental units.
Okay, well, I didn't understand you.
Yeah, I was talking about
I know what you're talking about, but I didn't know how
condos that are
it's
owned
like.
individually.
Okay, I'm sorry.
Yeah.
I have just a suggestion. So for us, we'll have a lesser violation, and for you to have a lesser job. My suggestion is, could you please furnish us guidelines or a list of your requirements as far as the building? For example, a battery backup exit sign. Do you require a battery backup? Or, for example, again, a light bulb naked without a fixture? Things like that. Should we know more?
The Fire Prevention Bureau can probably answer that better, but if you have a working exit sign right now that is not battery operated, that is acceptable. Is that correct? Okay. If you have an exit sign that is in disrepair and you need to replace it, it must meet the code, which is it must have a battery backup.
No, but that's only an example with that battery backup. How about this light bulb without a fixture or a cage? A naked light bulb should have a cage, because if you bump your head there, you'll get electrocuted.
Doug, do you know what he's talking about?
You know, there's a wire cage available or a globe. Yeah, at least those two are just an example. You might have other requirements that you.
Oh, in the inspection list,
Yeah.
I gave you an inspection list there.
Is that all the requirements
Yeah, you can go by,
Okay.
yes. Just
Well,
go through
that's
that,
all I'm
and-
concerned
And that'll
with, yeah.
give you an example
Right.
of what, everything that we'll be looking for. It's not all-inclusive, but it pretty much covers everything that we'll be looking for.
But back to my example, do you require a light bulb to have a cage?
Have a cage around
A
it?
cage, like there's a light bulb on the closet. Somebody said there should be
hallway
a.
lights.
No, not only hallway lights. There are lots of ceiling
In
lights.
closets?
In a closet.
In a
Those
closet, yes.
those are naked light bulbs. Somebody bumped their head there, it'll be electrocuted. Somebody
Yes.
said there should be a wire cage or a globe, a
A
fixture.
globe, yes, and that is in your inspection checklist.
Oh, I haven't read the inspection. Okay, thank you.
Okay?
I have a follow-up question to the gentleman back here who was talking about the 7-day notice to the tenant. I thought when we went through all these other earlier meetings that at the same time, if you notified the tenant, you would also notify the landlord so that if he can be of help or make the tenant feel comfortable, he could be there, he or she.
Right. We're going to notify both the owner and the
Okay,
tenant.
because that wasn't said today.
Oh, I apologize. Yes, both.
Okay, because remember, we have a lot of foreign people that are here.
Exactly.
Came from Europe, and it was stated earlier about communist
And
states
we
and so
obviously
forth.
would feel more comfortable, even if we have the written consent, if they're not there, that you are present with us also.
Yeah, but they do have a fear of that.
Right.
I got a couple of questions here. In the checklist, you say you need agreement with the managing agent and also statement from the janitor or engineer's authority. If I'm doing the same thing, if I'm doing it for, I don't have any managing agent, can I sign for those two and give you the statement, or?
You don't have to have a managing agent, you don't have to have a janitor, so you don't need any of those.
So I don't need any of them?
No, sir.
The second question I have is on the inspection. You say for the re-inspection, you're going to charge $50. Now, what are the basis of re-inspection? Let's say you come in, I don't know what you're going to look for, what you're going to find. You come in and do the inspection, and you find a couple of two things as items to be corrected. Now I go and correct it. Are you going to come in and inspect and charge me $50? Or how is that going to work?
If I have to come and do a re-inspection, it will be a minimum of $50.
But before you inspect, I don't know what you're going to find.
Well, the initial inspection is included in your initial application fee, and that's why I've also provided you with a copy of the inspection list. So you can go through that, walk through your building, take that list, and that'll at least give you an example of things that I'll be looking for, so hopefully you can take care of those issues, if you have any, before we get there.
That's what the checklist is for. That's what we're going to be looking for when we do the inspection. So you go down that checklist and make sure that your building complies with those items, then you don't have anything to worry about.
Thank you. Would it be possible to, to avoid even a reinspection would be to create a work order and attach copies of receipts and mail that to the inspector to showing that it's been corrected? So you don't need to do a reinspection, or would that be adequate?
We'd talk that over with village legal counsel and see if that's an acceptable thing.
Yeah, I mean, that way, I mean, something that's not, all these minor little things. Yeah. I mean, and one other thing, on the inspections for storage, if I have it marked on each of the storage bins, whose storage bin belongs to which tenant, would the inspector just go into the one that he's got permission from, the storage bin for the tenant that he's got permission to enter?
Well, Mr. Baum, are those storage areas in a common area?
Yeah.
Okay. See, we do inspect common areas, and we have a great concern about that. You'd be amazed at the number of times we'll go into common areas where there's a boiler or a water heater that's gas. Yeah. And people have got paint thinners stored right next to it. That's dangerous, and we want to catch those things. That's exactly what this ordinance is designed to root out and make sure that it doesn't happen. We want to inspect those common areas in those storage bins to make sure that no dangerous chemicals or hazardous animals are being stored in them.
Okay. Yeah.
That's important. That's very important to us.
Yeah, so if they're in the common areas, they'll be inspected.
Yeah.
Okay.
We didn't forget you.
One additional question.
Sure.
And again, it's a Willow West apartment complex. During your inspection, have you discovered that some of the apartment buildings that were that should be a 4th flat only, now there is a 5th apartment in it?
Yes, we have.
My question is, what have you done about it? Have you grandfathered that, or are you going to ask, since those apartments were illegally created,
yes, ma'am,
are you going to ask them to do away with it and convert it back to a 4 or a 6 flat?
Right. In that particular case, that owner has 2 options. One is to revert it back to its original, or the other one is to have an architect or a design professional do an inspection and make sure that it meets all the building codes for a legal dwelling unit.
Now, my next question is then, is there any way we can obtain from you which buildings you have approved now to be a 5 flat instead of a 4, or a 7 flat, 7 unit instead of a 6?
I believe your homeowners association will probably have that information, or should have that information. Don't we pass that along to the association? I know that it gets passed on to the assessor's office because a certificate of occupancy has to be issued, and that gets passed on to the assessor.
And you're telling me that this was passed on to the association.
I'm not certain about that, but I do know that we have to issue a certificate of occupancy for that dwelling unit, and C of Os get passed on to the assessor's office so that they can assess that property properly.
But there
I
would
might
be
be
a
able to answer that.
building permit issued too, so.
Correct.
If anything, you could always file a Freedom of Information Act, and then we'll have to provide the information if the board wants to do that.
And we'll be happy to freely provide that information. If you have questions about a specific address, please call us and we'll readily share that information with you.
Hi. I have an inspection list which need to check the balcony, and on the required action says you need to have a structural engineer to certify your balcony or something. Now my question is, I check my balcony. If I need to repair, I need to hire the contractor to do it. But if I repaired, do I still need to hire the structural engineer to certify? Because that's a different thing. Or
Is that contractor a structural engineer and an architect?
No, contract, like I talk to structural engineer and no one to does the repair thing.
Okay, let me ask you this question. What qualifications does that contractor have to tell you that that balcony is safe or not?
They have a building, like a building
They know how to construct things, but do they know how to test a joist or a post hole or a ballast? Do they know how to test live loads and dead loads to see if it's structurally sound?
So you means even we have repaired, we still need the structural engineer.
We strongly recommend you have a structural engineer and architect. Based on the number of balcony collapses, especially in the city of Chicago, you always hear about those. You don't hear about them in the surrounding areas. If we feel that there is visible damage on the balconies on your buildings, we will ask you to get a structural engineer or an architect to assess that balcony to see if repairs are needed on that balcony.
Okay, after structural engineer have the report, you need to do some repair thing. And after repaired, we still need to ask the engineer come back to make sure?
No, what you do then is you would take that report, he would do some drawings, you would hire a contractor, get a building permit, and that contractor then would go off of those drawings, construct it, we would do the inspection, you'll be all done.
Okay, I'm done.
Other questions?
Just a point of clarification. I didn't see anything in the instructions to the application that we had to attach the drug-free rider for each apartment to it. Do we have to do that?
Let me see. Yes, it's on page 3 of 4, right before all the signatures.
Okay, it does say we have to attach them. Thank you.
Yes. Well, it doesn't say that you have to attach it. It says that you agree to have all of your tenants sign it. It is the ordinance, in fact, that says you must attach it to the application.
The application is then unclear as to what has to be on the application.
Yeah, we could change that.
How many?
Go ahead.
How many balconies have collapsed, and how many people have died in the last 10 years in
Here
Westmont?
in the village,
in Westmont.
The fire department can answer that.
Actually, I will tell you, one summer we had 3 balconies at one complex collapse, and no one died, but there were certainly broken bones and back injuries from the 3 balconies alone. We have had numerous other balconies that were unstable to the point where the residents never used them. And the residents have no recourse to get them fixed, which is part of this. Is twofold, it's to make the landlords responsible for the property, and it's to make the tenants responsible for their actions. So that's part of this whole program. But yes, we did have building collapses, and we have pictures that if you want to file freedom, I can show you.
So that justifies the whole thing.
That's just part of the package.
Any other questions? Right over here.
I'm sorry, but regarding the balconies that we were just discussing in that, I talked with the fire department. I understand that I have to send a letter out to everybody saying that they must remove any type of electrical ignite, barbecue, whatever, they must be removed from their balconies.
Any open flame cooking source. Yeah,
Right.
Any open flame. On combustible balconies. Does everybody know the difference between a combustible balcony and non-combustible? Combustible is something that can burn, basically, okay? Non-combustible is made of concrete or something that doesn't burn.
Right. Well, my question is that, okay, I send these letters out. When I first sent out the letters last year, there was all sorts of hell raised because people want a barbecue. And that, then I said, okay, they can go in a common area, which of course, we don't want it in a common area because who's gonna carry a hot coal, barbecue, 3 flights up the stairs? Now, if I say to these people, all right, you have to remove everything off your decks, they refuse to do it. Do I call up the fire department, have the fire department take action on them? Because they will turn on that barbecue at 5:15 after I've left the property.
I'll let the fire department answer that for you.
Absolutely, absolutely call us, and we'll address it. When we try to be cordial, and it's not even part of this. This is a code, a building code that pretty much the whole state of Illinois uses, and of course multiple other states. It's just an adopted fire code, and we will address it with the resident, and we'll try to explain it. If you've made your attempts to do it, you're great as a landlord, and we appreciate your help.
And we can act, if we get a tenant that refuses to cooperate, I believe we can write a ticket
Oh, yeah,
for
we'll
violation of the
definitely
fire
cite
code.
them. But we try to work with the tenant and explain why we're doing this. And if not, we follow it with police, and they'll come and issue a citation.
Okay, thank you.
Here we go. One more question over here. Hold on, we'll get you the microphone, okay? And I think we're pretty much on schedule. We were hoping about an hour and a half.
If a tenant uses a balcony and as a storage for barbecue grill, which is very expensive and never using it, can he have it like a covered, and can he have it on a balcony or not? Because he said he's got to move and go to another apartment or someplace else.
You ask a good question. I mean, obviously, I understand if it was my property, I'd want to protect it, and I want it close to me. But unfortunately, it doesn't say use. It just says they cannot have a gas, propane, or charcoal grill on a combustible balcony. That's what the code says. I can show you the code, and certainly if we see them using it, that's a citation. But we enforce that they just get removed from the balconies. That's how we read the code, and I'll be glad to show it to you.
I have one more question. My daughter, she cleans the hallways and she washes the windows. So she goes to college, so she makes the money. Does she has to have a, fill it up as a permit for her name and everything? Because she's responsible for doing it. She's in a college and she's making the money extra. And I try to teach her, So this is a question if I have to supply her name or whatever.
As a tenant?
She's not a tenant. No, she's my daughter.
Is she an owner?
Yeah, sure, she's the owner, because if I die, she's the owner,
No, does she own it now?
She owns that, through my trust, She owns it through my trust. If something happened to me, so she owns it.
She's just a beneficiary at this point?
Yes.
No, only if she is an equitable owner at this point.
But I ask, I hired her, I pay her. She pay taxes. If I have to supply her on the license, like you're required to.
If you hired her as a managing agent or a janitor, then yes, you need to add her onto the application.
But she doesn't want to be window wash. She want to be clean vision technician.
All right. All right, are there any other questions? One more over here.
Wanted to ask for a clarification on something, Vicki. When you come and inspect and you find that there's something in the apartment that requires a reinspection, when you come to do the reinspection, you're only going to look at that one item.
That's correct.
So it's not going to morph into all of a sudden now there's other things. So because if that were to happen, then our license is being held hostage.
Right.
Okay.
When we go to do an inspection, we're going in there with a checklist, okay? And we're going to give you a letter of violations. It's just like a building inspection. We go in there and we see a violation. When we go to do the reinspect, we're reinspecting what we cited you for previously. Now, obviously, if there is some serious hazard that all of a sudden appeared, that's a different situation. But when I reinspect, I'm going back there with my letter, with my checklist that I cited you with previously. We're not there to continually looking. Otherwise, sometimes we would never get out of it.
Well, and not only that.
And that's not fair to you as an owner.
If we don't pass the inspection, whether it's a re-inspect or a re-re-re-inspect, we don't get our license then.
That's correct.
Because we only get the license if we pass the inspection fully.
That's correct.
Okay.
Right. You are absolutely right.
Okay.
Any other questions? All right, that's great. I was hoping an hour and a half. We ran a little over. We had some great questions. Really appreciate all of you coming. I hope it was helpful and informational to you. Please feel free to call our office if you have any other questions, if you need copies of any of the information. I did promise you more clarification on the irrevocable consent. We will get that opinion and get that mailed off to you. Again, feel free if you want to attend another session. We will be covering the same information. But if you do want to attend another one, feel free to. And we thank you very much for coming in. And have a great day.